welcome to Arbitration Acumen, a podcast from Bracewell's International Arbitration Group that connects in-house counsel and arbitration practitioners with industry experts, institutional insiders, and top arbitrators from around the globe to share their views on key issues in arbitration today. You can reach out to any of today's speakers by emailing arbitrationacumen@bracewell.com. And we hope you enjoy this episode of Arbitration Acumen.
Welcome back to the next episode of Arbitration Acumen, in which we'll discuss the ICC, its office's 10-year anniversary in New York, and its future plans in North America with Marek, Krasula, and Abbey Hawthorne, the Director and Deputy Director of Arbitration and ADR for the ICC in North America. I'm JP Duffy. I'm an international arbitration partner based in New York that acts as both counsel and arbitrator in international arbitration seated around the world under a variety of governing laws and arbitral rules. I'm qualified in New York, England, and Wales, and the DIFC courts in Dubai, where I previously practiced. In addition to representing parties in international arbitrations around the globe, and particularly under the ICC rules, I regularly sit as an arbitrator in commercial disputes around the globe as well. With me today is Marek Krasula, who is a Canadian attorney based in New York and is the Director of Arbitration and ADR for North America. Marek's primary responsibility at the ICC is to promote the ICC's dispute prevention and resolution services throughout the United States, Canada, and the Caribbean, and to work with businesses and their legal teams across North America to help them find the right tools to mitigate risk and manage conflict in a domestic or cross-border business context. Before entering his present role, Marek led the North American case management team at the Secretariat of the ICC International Court of Arbitration, where as counsel, he oversaw hundreds of arbitrations under the ICC rules of arbitration from a broad range of industries. Notably, Marek has been with the ICC's New York office since its inception over a decade ago, so he'll be able to tell us about the ICC's last 10 years in New York and North America, as well as his future plans for the region. Our second guest today is Abbey Hawthorne, who's the Deputy Director for North America, and she's been in that role since 2022. Prior to her role as Deputy Director, Abbey was an adjunct professor at Arizona State University's Sandra Day O'Connor College of Law and worked at firms specializing in business immigration law and litigation in Arizona. Abbey holds a JD from Arizona State University and focused her legal studies on international commercial arbitration and alternative dispute resolution. She was also a 3-time U.S. Department of State Title VIII Fellow. So as you can tell, we have great guests today, and I'm looking forward to hearing from them. Before we do, though, I want to give a bit of background information about the ICC and its history in North America to set the table for our discussion. While everyone who practices in the international arbitration space knows the ICC, not everyone may be familiar with its full history, which is particularly interesting in the present climate. The ICC was founded in 1919 in Paris in the aftermath of World War I by a group of entrepreneurs who called themselves the Merchants of Peace to further their belief that strong and mutually beneficial commercial ties between nations would make them more prosperous and less likely to fight with each other. In 1923, the ICC Executive Committee approved the creation of the ICC International Court of Arbitration, which is the ICC body that supports global trade by providing dispute resolution and prevention services, predominantly by administering cases under the ICC arbitration rules. The ICC court is not really a court in the traditional sense of the word because it does not resolve disputes, issue formal judgments, or final awards. Instead, the ICC court administers the resolution of disputes by arbitral tribunals under the ICC rules of arbitration, reviews draft awards to improve their quality and enforceability before they are notified to the parties, which is called the scrutiny process, and makes non-merits decisions on issues such as appointing arbitrators, deciding on any challenges made against arbitrators, fixing the seat of arbitration, and setting and adjusting arbitrator fees. The ICC court therefore plays a critical role in the process, but it's not charged with making merits determinations on any particular dispute, which is left to the tribunals. The ICC body that does the day-to-day case management work is the ICC Court Secretariat, which is presently made up of more than 100 lawyers and supports personnel located in offices in Paris, Sao Paulo, Singapore, Abu Dhabi, Hong Kong, and of course, New York. So with that, let's start talking about the work that's being done out of New York by Marek and Abbey, which is really fantastic. And let me welcome you both. Marek, thank you for joining today. And Abbey, thank you for joining as well.
Thanks for having us.
Thanks for having us.
So for the audience's benefit, the ICC opened its New York office in late 2013 through a nonprofit organization called Sakana. The ICC's New York office provides ICC arbitration and other ICC dispute resolution services and administers cases mostly with a North American or Americas component. It also organizes arbitration-related events around the region. At the time the office opened, North American parties made up 8.4% of the court's 2012 caseload. And as the president of the ICC court at the time, John Beachy, said, that made New York and North America one of the ICC's most important markets. Since its opening, U.S. and North American parties have continued to play a significant role in the overall ICC caseload. And to give you a sense of the scope of the ICC's global caseload, it administered 841 new cases in 2024 for a total value of $102 billion in dispute. And 9% of those cases came from North America, while 30% overall came from the Americas generally. So as you can tell, the ICC New York is extremely busy. Now, Marek, of the new cases at the ICC in New York registered in 2024, what were the top 3 industries represented?
Thanks, JP. Sure, happy to share some statistics here. Looking at just the new cases assigned, that is, to our case management team in New York, the top 3 industries were energy, construction, and life sciences. To give you a sense of scale, our New York office receives on average more than 100 requests for arbitration every year. And that's roughly over 10% of all the new filings that the ICC globally receives, making us one of the busiest offices across the ICC court secretariat. The team in New York manages cases in English and now more often in Spanish too, with places of arbitration and applicable laws in the US, Canada, and sometimes elsewhere in the Americas. But coming back to industries, what's interesting is that if you look at the institution as a whole, construction comes out on top, followed by energy, but it's actually reversed in our region. In any event, what really stands out over the past few years is the growing role of the life sciences industry. And I'm sure this will be music to your ears, JP. It's a sector that we've seen increasingly active in arbitration generally, both, I think, reflecting the complexity of disputes in that space, but also the global nature of that industry. And I'm glad that we've gained the trust of that industry to administer their disputes. So in essence, it's the traditional core of construction and energy sectors leading, but also a clear rise in life sciences, which I think and hope will only continue.
That's really great to hear, Marek. That is music to my ears. We are certainly going to raise the task force that ICC has been so generous in starting. But before we do that, let me just ask, what are some of the other industries then that the cases are coming from that you're administering?
So beyond energy, construction, and life sciences, we really see a mixed bag of industries pretty much on par with each other. A big portion come from telecom and technology industries, also transportation, which includes aerospace disputes, financial services, insurance distribution. I think I can go on and on. What's quite fascinating here and unique is that ICC's caseload touches just about every sector of the global economy. And as we are talking about industry sectors, let me also just mention here something on how the technology sector is a good example of how the parties' use of arbitration is evolving and how companies are thinking about it now. As we know, speed is absolutely critical to keeping innovation on track, and speed is now often, for many companies, seen as important as the outcome of the dispute. And that's why procedures like our expedited procedure provisions that we launched in 2017, where you have this streamlined 6-month process for the dispute to be resolved, are becoming the starting point for many companies when thinking about arbitration, and especially in industries like the technology sector. So all of that to say, I suspect we will see more growth there over the next few years in terms of the use of the expedited procedures, which have been quite successful, but also in terms of technology disputes, broadly speaking, playing a larger role in our New York caseload.
That's really interesting. Before we turn to a couple of other questions, I just wanted to expand a bit on the discussion about the expedited procedures because they have been really successful. What's the current threshold for cases to be moved into the expedited procedures by default?
So it's currently 3 million. We see parties also opting in for larger amounts in dispute. It initially started in 2017 at 2 million, and we increased that threshold to 3. We are in the process of an ICC rules revision right now, so there is some discussion about whether that threshold is still the right one. But I can say, after 700 or so cases, the process works. There were a lot of questions as to whether it was possible to write a high quality award within a 6-month time limit. Was it even possible to present a case within that 6-month time limit? And experience shows that it's been a resounding success. And we'll see how can it be improved. And I should also mention our think tank, the ICC Commission on Arbitration and ADR, has a task force dedicated to the expedited procedure provisions, who is looking and analyzing different best practices that can then be relayed to arbitrators and counsel, so they can then inspire themselves from that as we further develop the process of the expedited procedure provisions.
Yeah, that's a really interesting discussion too about the threshold amounts, because it highlights, the tension between doing things quickly and doing things well, and finding that sweet spot between the two. Just out of curiosity, if you know off the top of your head, what is ballpark one of the largest cases where parties have opted into the expedited rules?
From what I can recall, it was about $100 million. And it's interesting because there's always this danger of confusing quantitative with qualitative. It may be a large amount of dispute, but a very simple issue of contract interpretation to be resolved, while a very small amount of dispute may actually be a very complex dispute in terms of technicalities. There's been a few cases where parties have opted into the process for very large amounts of dispute. And that is, I believe, also a testament of the success of the process, that you not only see smaller cases in terms of value going through this process, but also larger ones where parties are really putting a lot of emphasis on predictability and getting an award within the 6-month time period.
Yeah, that's really interesting. And certainly, as you mentioned, tech, certainly there are life sciences disputes where that would be the case. I can see any number of industries that would benefit from an expedited process, despite what might otherwise be a pretty substantial amount in controversy. Because as you say, if it's a simple case, it's a simple case. And that's the right kind of case for an expedited process. Abbey, let me turn to you for a second to ask you a question about the number of cases that involve parties from the same countries, because I know there's been, at least surprising to me, the number of cases that involve, say, both U.S. parties or what would be otherwise considered perhaps domestic arbitration have been pretty substantial. So what are some of the statistics around that?
Yeah, JP, and that's something that is honestly one of the big myth-busting items that we have people ask questions about quite often, which is we get but I don't know if you could handle the case because it's between two U.S. companies. And we say, yes, we can. Actually, 20 to 25% of our cases every year are what are considered domestic. So 2 parties from the U.S., 2 parties from Canada, or anywhere else in the world that are actually businesses from the same country still seeking ICC dispute resolution. And that's because if you're drafting a contract between companies located in California or Colombia, or California and Colorado, we can handle both of those cases. And the reason that those parties tell us that they're putting us in their contracts, even for domestic cases, instead of opting for the courts, for example, are the same reasons that parties come to arbitration in general. They want those expert decision makers. They want to have a say in the process and have the flexibility of arbitration, and also the desire to opt for confidentiality are some of the top reasons. And they come to ICC because they want that quality of service that we provide regardless of who the parties in the case are. And finally, something else that we've heard a lot is similarly to companies that make the decision to opt for the expedited rules because that's just part of their company process and culture. They also sometimes opt to keep their entire portfolio of contracts with one institution. And we are an institution that can handle both the largest international cases and smaller and or domestic cases. And so they want to keep all of their contracts with us and with an institution they know and trust.
Yeah, that's a real testament to the quality of services that are being provided, because most people, I think, don't appreciate that it is entirely possible to have companies from the same country opt for ICC. Now, there are certain countries, anecdotally, I think that, or certain jurisdictions where you see that more as a more common process. And my understanding has always been Brazil has been a very common one. How common is it in the U.S.?
In the U.S., it's usually about 25% of our cases every year are domestic U.S. cases. So we're also up there in this statistic.
Wow. Okay. So 25% of the overall caseload, which is, and the U.S. represents, is it am I recalling correctly, 9%, 10% of the overall caseload? So that's a very substantial number.
Yep.
Wow. Now, is there a push on to increase that number?
I mean, we always want people to see us as their one-stop shop for their dispute resolution services, be that for arbitration and mediation services or for their international and domestic cases. So that's definitely something we continue to talk with businesses about and with lawyers like yourself who are advising their clients in best practices for their dispute resolution clauses.
Yeah, well, that is always a common question that we get. And certainly, there are a handful of industries that really are focused on that. And we do tell them, look, it's perfectly permissible to do that. It's a great idea for the reasons you outlined. I personally like to tout the arbitrator expertise and the confidentiality aspects because I think those resonate very clearly with general counsel. I think the other one that really, the general counsel hear very clearly is that there's a much more limited disclosure process or information exchange process that is much more streamlined and a lot more rational at times. And I think that resonates pretty clearly as well. So I'm sure that trend will continue. Let me shift gears a bit and just ask you, Marek, a little bit more about the New York office, just so that the audience has a sense of how the scope of what's going on here. How many people are employed in the New York office at the present time?
So at the present time, our New York office is home to 50 people in total. That includes our case management team, but also our colleagues who engage with the United Nations. And that's something unique about the ICC. We're the only business organization with UN General Assembly observer status at the UN. So New York isn't just a case management hub for us. It's also our bridge into kind of global policy discussion that impact business.
Wow. Yeah, that is definitely unique. Now, how many case managers are there in New York?
So on the case management side, specifically, the team is a lean one, but very active. Our counsel, we have the wonderful Paul DiPietro, who leads the team, our 3 enthusiastic deputy counsel, Winlian, Kelly, and Andrea. And we also have currently 4 case management assistants, Diana, Abbey, Juliana, and Miguel. And many of your listeners may know this team through its acronym in email addresses, ICA9, which is basically team number 9 of the ICC International Court of Arbitration Secretariat. Bit of a mouthful, but you often see this acronym circulating everywhere, ICA9. So Abbey mentioned myth busting. We're doing some of it today with you.
Yeah, that's a good one. That's a good one too. That's a good one to keep in mind. And I would encourage people to say ICA rather than pronouncing it, because ICA9 is slightly different than the acronym is pronounced, which is another organization in some respects. But well, Paul is obviously leading quite a team then. What is his current caseload?
So, more or less, I would say there's about 200 ongoing cases in the team. So each deputy counsel manages on average, I would say, about 70 cases at any given time, which gives you a sense of both the scale and the expertise that him and his team bring. And I'm glad you asked the question, because I always encourage practitioners not to hesitate to call their case managers, right? We're not a judge's chamber. You won't spook anyone by calling, and it's not inappropriate to call. They have a wealth of expertise. They're all attorneys with previous exposure to international arbitration. They've seen hundreds of cases. They work with arbitrators and counsel from every region in the US and Canada and elsewhere. And of course, they can't give legal advice, but they can share what they've seen while maintaining strict neutrality. They can also answer questions about the application of the rules. And if there's anything they can't answer, they will, of course, let you know. And in my view, this is one of the most underutilized resources in ICC arbitration, having that direct line to someone who knows your case, but also who knows the broader landscape of ICC practices. That, I think, is incredibly valuable, especially for attorneys in North America. So my recommendation is make the most of it. They are there for a reason, and don't hesitate to pick up the phone and give them a call.
Well, I know I certainly don't. And in fact, I called Paul about 2 weeks ago with a rather thorny issue. And I have to say, I was immensely impressed with how well he knew the case I was calling about. And that's always been my experience. Anytime you call, people actually know what's going on in the case. And they may say, give me an hour or 2 to go look at things or to get up to speed. But when you get on the phone and you start discussing it, they are fully informed. So Something to keep in mind for the audience because it really is an impressive level of knowledge. And as you say, they're a great resource that will be as helpful as they can be. And I think very, very user-friendly. So to be commended.
Well, we'll make sure that the team hears about this podcast.
Exactly. Let them know how well they're doing. Now, how does the New York office interact with the other secretariat offices then? So there's ICA 9 in New York. How is it interacting with ICA 6 and ICA 4? And is ICA 4 Paris? Is that right?
I believe so. Exactly. It is one of the teams in Paris.
Okay.
Yeah. And let me tell you a little bit about it. I guess one of the connected questions is, folks often ask about the level of service between the different teams. How is it different or is it not different? And so, there's really no difference in the level of service provided by our New York office versus the teams in Paris, Hong Kong, or any other of the ICC offices. Parties and arbitrators get the same services regardless of, where their case is administered. And that's by design, right? And of course, in Paris, there's the wonderful ICC hearing center that can be used, or in Brazil, our team there is responsible for cases, for Brazilian domestic cases, or those that, have a strong connection with Brazil. But otherwise, you pretty much get from what you get from your team is what you get from all of the teams globally. So now in terms of, how they work together, all of our case management teams around the world are in close contact, right? They have weekly staff meetings. They make sure practices that they apply are uniform, and our teams attend many of the same court sessions. So basically everybody is looped into the latest court decisions and developments, and that consistency is really important. What that means, practically speaking, for the team, it means that they can draw on insights and experience across other offices of the Secretariat and still provide all of you kind of the convenience of a local presence, right? Being able to kind of interact with practitioners in the same time zone. So as we were talking before, you can pick up the phone, call your case manager in your time zone, or at least you feel you're much closer to them. And you don't need to worry about calling Paris at odd hours, or as some people used to joke about speaking French, they are here. So that has been really a big game changer. And a key point here, something to remember is, as we were discussing calling your case manager, definitely call the case team assigned to your case. The New York team can answer questions about the cases it is administrating directly, but while cases that are based elsewhere are best handled by the team in that office. And this really ensures that you're getting the most accurate and relevant guidance. And that said, if you have general points of inquiry, team members in New York are always happy to assist.
That's great. Now, do the case managers in New York handle cases outside of the Americas ever, and vice versa?
It's a mix. I was talking about it very briefly at the beginning, right? I mean, you do have some cases that may have a seat outside of North America, outside of the US or Canada, maybe somewhere in the Caribbean or South America. But usually the cases that this team handles have some form of connection to North America. So you always try to look for this, I guess, the center point of gravity, if I can put it that way. And if it makes sense for the team here to administer, then it is assigned to this team here. Otherwise, those cases are assigned to a different team, which for a variety of reasons may be better suited to administer a particular case. So the team here, generally speaking, I think it is the one assigned and dedicated to cases that have a connection to North America, and now sometimes even to the wider Americas.
Oh, that makes a lot of sense. Well, let's shift gears a bit then and just talk a bit about, where the ICC is going in North America, because with the ICC court having just celebrated its centenary and the ICC court secretariat's office in New York having celebrated its 10-year anniversary, it's a natural time to reflect on past accomplishments and plan for future ones. So, Marek, what do you see as the ICC's most significant accomplishments over the last 10 years in North America?
When I think about our accomplishments over the last 10 years, I think a few things stand out. First, it's worth remembering that U.S. parties remain the number one source of cases in ICC arbitration globally. Sometimes people forget that. I believe Abbey was referring to that before, that the United States leads in this space, and it's a testament to the relevance of ICC arbitration for American businesses. Second, it's gratifying to see the recognition from the community. And what I mean by that is in the Whiting case and Queen Mary surveys in both 2021 and 2025, ICC was the most preferred institution and its rules the most preferred framework for arbitration in North America specifically and also globally. And that kind of acknowledgement, I think, reflects the trust and reputation we've managed to build over time in the community. Third, and we've been talking about this quite often now, having that local presence has been critical. Being physically here allows us to engage directly with the U.S. legal and business community, both the domestic and international community. And over the years, we've made countless trips, met with in-house counsel, law firms, arbitrators, companies across different industrial hubs. And you simply can't build that kind of trust and understanding without being on the ground. If I had to highlight, I guess, one accomplishment personally, it's prioritizing in-person visits, right, with in-house counsel across the US and Canada, discussing how we can improve dispute resolution processes to meet their needs. That direct exchange is consistently what people tell me they really value the most. And finally, I think we've continued to grow also the community of dispute resolution professionals across North America. What I mean by that is, by supporting our ICC YAF representatives and their local capacity building events for young practitioners, to also launching last year the ICC Advanced Arbitration Academy for North America that helped we're hoping to develop the next generation of arbitrators through it. And of course, through different programming for companies, firms, and universities, this office has really played a crucial role in skills development, and we want to continue doing that in the future. So when I take a step back, I'd say the last decade really has been about building trust, connecting locally with businesses and legal communities from coast to coast, and really investing time in the next generation of dispute resolution professionals.
Well, I will just throw a very quick plug out that I always tell associates, please do sign up for the YAF. It is a wonderful, wonderful opportunity to get involved with practitioners around the world and in your jurisdiction to learn about what's going on. And it really does set you up, as Marek says, to be the next generation of practitioners and potential arbitrators. So a really, really important thing to get involved with. Now, Abbey, let me turn to you for the really hard question, because here's the one we've been waiting for. What's been the biggest challenge in the last 10 years? We gave Marek the softball. He got to talk about what was great. Now you tell us what's been challenging.
Gosh, JP, leave me the fun stuff.
Exactly.
Well, the first thing that comes to mind is surprising to some and not at all to others. Our counterparts in other regions have an array of countries that they work with, speaking different languages. So on one hand, it seems natural that, well, your jurisdiction's kind of easy. Your region's not too bad. It's two big countries in the Caribbean. But as anybody who covers the Americas knows, the US and Canada are very big with lots of different industries and markets and even legal cultures. Speaking with a lawyer in Boston versus a lawyer in Texas versus a lawyer in Calgary is going to have a very different feeling to it. And the way that they practice law and even specifically arbitration varies. And what that means for us, besides lots of time on planes to make sure that we're making those contacts and able to be local for folks, is that we are constantly refining our services. So that is the core offerings of ICC and also the messaging and capacity building support that Marek was just talking about with our educational programming and different organizations for getting folks involved in ICC and building their own careers with ICC. So from those services and that capacity building side of things to ensure that what we're doing is meeting the needs of companies and arbitration professionals all across the country. So from the US, from Canada, from the Caribbean, making sure that we are doing what is needed for individuals, regardless of where they live, regardless of where they practice, regardless of their industry. And that's, I think, an ongoing challenge that we deal with on a daily basis, but is important to the ICC continuing to offer that global service. Global, yes. International, yes. We have this expertise and ties, but also the local tailoring and the local flavor that's necessary to be the best service provider.
Well, I can tell you it's being successful because one of the things, we were talking earlier about domestic parties using ICC or opting for ICC. One of the things I do here in that context is, you're going to get the same level of service and the same process, regardless of where within the continent these cases arise from or the parties hail from. So clearly it's working, and clearly you're meeting the challenge. So we gave you the hard question, and you You stepped up and hit it out of the park, of course. Well, let me just ask then quickly, as we're getting towards the end of our time, so much has been accomplished in the first 10 years. What would you like to see happen in the next 5 or 10? Where would you like to see ICC in North America in the next 10 years, Marek?
Sure. So this is also a pretty hard question, it's like the challenge. But let me give you some thoughts here about, where are we going in light of where we've been so far. So first, we have the ongoing ICC rules revision process, which is happening right now, with a new set of rules going into effect likely next year, 2026. And it's critical that the services and tools that we provide from New York or globally continue to meet, as you were just saying, meet the evolving demands of business and emerging industries across North America. But what's really equally important, and it was when I was also counsel of the case management team, and it is also now when we do our promotion and educational services, when we do that work across the continent, is responsiveness, right? As a service provider, how quickly and effectively we respond to emails, phone calls is often what makes or breaks our reputation. Timely, attentive communication is central to building trust with parties, counsel, and arbitrators. And, maintaining that kind of responsiveness is just as crucial as the rules themselves that I was mentioning before, because even the best procedures won't work if the people administrating them aren't accessible and proactive, right? So we need to make sure that we step up for every case, for every project that we undertake. Second, I'd like to see, as you were discussing with Abbey, the number of domestic cases grow, while we continue to be the go-to forum for international disputes. North America, is a dynamic market. There's a real opportunity to show that ICC arbitration works just effectively for domestic disputes as it does globally. Third, I would say, and in connection with the domestic element, is really about better serving all regions and continuing to grow our presence outside the traditional arbitration hubs. ICC arbitrations are already seated in many places across North America, not just in New York, DC, or San Francisco, Montreal, Toronto, Vancouver. They are in the Midwest, they are in the Southwest, they are in the South, and we want to expand that further. So what does that mean practically speaking? Our plan is to travel to as many states and provinces as possible, meet with companies, chambers of commerce, law firms, local arbitration communities, to spread the ICC word and make sure that our services are accessible wherever businesses are operating. So over the next 5 to 10 years, it's really about updating the rules, remaining responsive, growing that domestic arbitration participation, and expanding our reach across the continent.
Well, those are certainly lofty goals, and I think they're ones that you are absolutely going to hit because you see it. You see it. I mean, in particular, when you look at the list of where cases come from every year there's a new city that I would not expect, right? That's used as a seat. So it's really, really impressive to see. Before we do conclude, I want to just very quickly talk about the Life Sciences Task Force that we mentioned earlier, because I think that's a pretty interesting undertaking. I'm really glad to hear that life sciences is one of the top 3 industries that you're seeing in recent case statistics. For the audience's benefit, that's a task force that came. Hagit Talul and I came up with that notion a few years ago. Marek and Abbey and everyone else, Peter Sherwin, have been great about pushing that ahead to make sure that that's moving and that's something that will be hopefully out within the next year and a half. But let me ask you, Marek, what would you like to see that report accomplish?
Well, it's really exciting to see USCIB, essentially ICC USA, our national committee, kind of undertake this task force. And what I'd like to see is twofold. I think it'd be great if it would kind of highlight the industry specific needs and concerns. Life sciences is such a fast moving, highly regulated, innovation driven sector, and understanding the types of disputes that arise, the challenges that companies face, I think is essential. Second, hopefully the report can provide some insight into how we as a service provider can best support these companies, what arbitration procedures perhaps and resources tailored to the sector should we be considering in the first place that are perhaps flying under the radar. And we were talking about myth busting or debunking myths before, and of course I hope the report helps debunk strongly held myths about arbitration in that sector. And helps more life sciences companies see that arbitration is not this kind of scary process. It's actually an important tool to consider to keep innovation moving, managing risk and, enabling growth, especially in the cross-border context. So JP, as one of the co-chairs, you have a lot of work on your plate. So looking forward to seeing all of that. No pressure, but it's a very dynamic industry. And I'm glad this is being undertaken under the aegis of our national committee. And then that you and others are part of it. And of course, it'll be great to see what in-house counsel thinks about, different parts of what will be discussed and studied. So really looking forward to seeing how this all kind of pans out.
Well, no, it's great. I was over in London about 3 weeks ago, actually less than that, probably 2 weeks ago at this point, to discuss this with a few GCs in London and from continental Europe. And I'll be down in Princeton tomorrow to discuss it with a few more. So it's gotten a lot of great attention. And I think it will be a very, very valuable, practical piece of work for various people in the industry to use. And before I forget, don't let me forget to mention Jason File, who's done an exceptional job pulling all this together and leading all this as well. He's given great leadership and great direction to everything. So thank you, Jason, as well, to you for all the work you put into that. Now, Abbey, with that, let me just ask quickly, are there any other industries that you'd like to see a task force considered for going forward?
Most definitely. We started this podcast talking about how ICC started as the Merchants of Peace, and we are a business organization to begin with. And like our colleagues on the policy side of ICC, we're also keeping our ear to the ground and looking at industry trends and seeing how we can best support business and trade, not only of today, but of the future. So when we look forward, our focus is on ensuring that our services continue to adjust to those needs of contracts and of transactions that are occurring today, 10 years from now, and 100 years into the future. So life sciences is a great example of a key industry in North America, but it's not the only one we're watching. We also have a finger on the pulse of California's constantly innovating technology sector, California and Canada and the US's evolving energy landscape and mining industry players, and the aerospace industry, for example. These are ones that you'll see pop up in a lot of the news day to day and a lot of the business transactions, and therefore a lot of the contracts and disputes. And stepping back from that industry focus, something else that is key in the US and Canada and the Caribbean are the vibrant communities of SMEs. So those small and medium enterprises that are the backbone of the economies here, and making sure that as we're looking forward, how do we best meet their dispute resolution needs too? That's another one of the myths that we bust often, is that we can only service large companies in large transactions and large disputes. About a third of our cases are actually under that $3 million mark that we discussed earlier, where the expedited procedures apply. So we also want to make sure that we are looking forward to how we can service large, small, and a variety of industries today, tomorrow, and again, 100 years from now, when the ICC court will be celebrating 200 years.
Well, that's great. That's great. And I am fully confident that will be the case. So, Marek, I appreciate that this is probably a topic unto itself. And I think what we should do is probably have you back to talk about this in more detail. But tell me, what plans does the ICC have for a market like Canada?
Sure. And as a Canadian, this question is especially important for me. The goal is to be present as often as possible from coast to coast in major Canadian industrial hubs, similarly to what we've done in the US. But as you know, recent developments have reinforced the Canadian business community's interest in diversifying international trade and commercial relationships. Canadian businesses and local chambers of commerce probably more than ever want to engage and learn how ICC can better support Canadian cross-border investment and strengthen SME participation in global markets. And as Abbey was mentioning before, the SME element is an important one. A lot of the trade that Canada does is also through its SMEs. And I think this is an opportunity to show how, and we often hear the theory behind this, but I think it's a great opportunity to show how trade, investment, and trusted dispute resolution mechanisms go hand in hand to drive global economic opportunity, and how arbitration and other ADR tools can actually play a key role in mitigating risk and providing, the predictability that companies need to expand cross-border trade. So all that to say, what we're seeing growing interest in Canada for ICC know-how about dispute resolution. Not that it's not already the case. There's a healthy amount of Canadian parties participating in ICC arbitration every year. But that need, I think, will grow as businesses worldwide expand their relationships with Canadian energy and natural resource companies. And I do expect to work closely with Canadian energy and natural resource companies, for example, business associations and chambers of commerce as these investments grow. And as we talk about Canada, I do want to give a special shout out here to our leadership at the ICC Canada arbitration community, Craig Chason, the chair, and his co-chair, the vice chair, I should say, Alison Fitzgerald, and to our friends at the Canadian Chamber of Commerce who continue to be instrumental in helping us achieve our goals in Canada. So in short, for Canada, it's really about being present locally, supporting Canadian businesses and ensuring that Canadian business, including SMEs, have access to trusted, predictable dispute resolution wherever they operate.
No, that's great to hear. And I think what we're going to have to do, because we don't want to give short shrift to such a critical and important market, I think we're going to have you back, and we're going to have to do a whole separate episode just on Canada, because there is so much going on. There is so much industry. There is so much cross-border work that can be done that we should really talk about it in detail. So I appreciate you raising that, because I think it will be a fascinating discussion for everyone involved.
Fantastic. Looking forward to it.
That concludes our update on the ICC in North America. I want to thank our guests, Marek, Krasula, and Abbey Hawthorne of the ICC for their invaluable insights. And I want to thank you, the audience, for listening. You should feel free to reach out to Marek and Abbey with any questions you might have, as I'm sure they'd be happy to speak. And you should feel free to reach out to Bracewell about today's podcast as well with any other questions you might have. You can reach us with questions by email at arbitrationacumen@bracewell.com. And we look forward to having you tune in for future episodes in the series. So thank you, Marek. Thank you, Abbey. And I'm certain you guys will be back talking again in the near future.
Thanks for having us.
Thanks so much for having us. Have a great day.
Thank you for listening to this episode of Arbitration Acumen. We hope you found it insightful and informative, and we encourage you to share it with your colleagues if you did. You can reach out to any of our speakers by contacting them directly or by emailing arbitrationacumen@bracewell.com. We welcome any questions or suggestions you might have for future episodes. And please subscribe to our podcast channel to stay up to date with our latest content.